So the Supreme Court has issued an order in the critical Second Amendment Preservation Act challenge that was pending in front of their court. So let's talk about what they just did and what happens in this case going forward. Now, before we jump into this video, I just want to ask you guys for a favor. If you want to support this channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, double check to make sure YouTube has not unsubscribed you, because they love to do that. And also just check the notification bell, turn on the notification bell, turn on all notifications, because that will help to ensure that YouTube will actually send you these videos. And also it just helps the channel to grow and signals to the algorithm that you appreciate this type of two-way content. Also, I want to thank one of the main supporters of our channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. Their culture is unmatched. It bleeds into every single thing that they do. And one of the really cool things about them is they're pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel. So if you guys want to support an amazing company and get great supplements like their protein powder, I really love their protein powder, their pre-workout. I use it whenever I work out. You can check them out using the links down below in the details section, also in the pinned comment. And if you use those links and you order something $100 or more, you can get free shipping on those orders, and they also have a money back guarantee. As I mentioned in the intro, in this video, we're going to be talking about a significant Second Amendment Preservation Act case that was seeking Supreme Court emergency review. This is a case dealing with a state's Second Amendment Preservation Act, also known as a SAPA law. We have discussed this case before because in the past, the Supreme Court issued an 8-1 order denying a stay which would have protected Missouri's SAPA law. This case actually went back in front of the Supreme Court, and we just got the Supreme Court's order and answer in this case. The Supreme Court in today's order list denied emergency review to this case once again, but however, this case is far from over, and there are still some positive things that have developed because of that denial. Now, you might remember that in this case, the Trump administration continued to argue that the SAPA law is invalid in some of its applications, and that the Supreme Court should deny review to this case. However, at the same time, they also stated to the Supreme Court that if the court denied review, the federal government would release some of the judgments that they received once the case got back in the hands of the district court. Missouri responded to that by pointing out that the concessions that were made by the Trump DOJ are exactly why the Supreme Court should deny review to this case. And this case went to Supreme Court conference on September 29th, and this Monday we got the order list. And in that order list, they denied emergency review to this case. And like I mentioned, this case is still moving forward and it's going to get kicked back down to the district court. But the United States government had actually said that they're going to concede and release some of the judgment that the Biden ATF and the Biden DOJ got prior in this case. Now, if you're not aware, this lawsuit revolves around a 2021 Second Amendment Preservation Act that passed in the state of Missouri. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violate the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce those laws. The law also created a civil remedy where anyone could sue a Missouri official if that individual helped to enforce a federal law that the state believes violates the Second Amendment. So the law aimed to give the true enforcement powers to the residents instead of the state and its officers and agents. In this Missouri case, the district court on review ruled in favor of the then Biden administration, striking down the Missouri SAPA law in its entirety, and they did that with an entire preliminary injunction, so essentially a universal preliminary injunction. Now, in response, the state of Missouri then appealed up to the 8th Circuit. Missouri at that time wanted a temporary stay on that lower court ruling, which eventually led this case to once at that time seek emergency Supreme Court intervention. However, on review, the Supreme Court issued an 8-1 order denying that emergency request for a stay. Only Justice Thomas was in favor of granting that stay. After the Supreme Court denied this case, it was then sent back down to the 8th Circuit for a ruling on that preliminary injunction, and that led to expedited arguments in this case. However, the 8th Circuit ultimately ruled once again in favor of the Biden administration, striking down the SAPA law entirely. But then, like I mentioned, Missouri once again responded by filing a writ of cert to the Supreme Court. However, I will mention it was still on an emergency basis. It was still dealing with an interlocutory issue. Essentially, there was no final ruling on this case, but once again, it made its way to the Supreme Court. Now, one of the big things that Missouri pointed out is that the 8th Circuit essentially said that the structure and potential operation of this law is valid, but ultimately the 8th Circuit struck it down because of its underlying Second Amendment purpose. Missouri argued that the 8th Circuit went against clear precedent and found that state officials could be sued because the court believed that the state played a role in enforcement by simply complying with the state law. Essentially, the 8th Circuit found that compliance and non-action was actual enforcement. Now, this law was originally opposed by the Biden administration, but now, like we all know, the Trump administration is now in control. And initially, they stalled the response for multiple months in the Supreme Court level. And eventually, we did get a response from the Trump administration after the two-way task force, I believe, took over this case. And still, the Trump administration continued to argue that the SAPA law is invalid and that the lower courts got the decision correct. However, at the same time, they argued that if the Supreme Court denied review to this case and it got back in the hands of the district court, the federal government would ultimately dismiss some of the judgment that prior was won by the Biden administration. The Trump DOJ argued that that judgment was too broad, over-comprehensive, which is overbroad in regards to what it granted to the federal government, and they said that they would release some of that judgment. On today's order list, the Supreme Court denied emergency review to this SAPA challenge. However, despite that denial, this case is not yet done and it still gets to move forward. As the United States stated in the request for the denial in the Supreme Court, once this gets back in the hands of the lower court, they will be releasing the total injunction that was issued by the district court. And Missouri and its SAPA law may still be able to be implemented in some ways because this is still in a pre-enforcement kind of mechanism. It hasn't fully gone into effect and they're not really sure, how this operates. So there may be an avenue where SAPA in this law gets to be put in place. And then the federal government and the state will kind of see how this plays out. And also the lower court will have to see, really how does this operate once it's enforced. So there may be some ways in which the SAPA law will be implemented as this case moves forward at the lower court level. So even though the Supreme Court denied emergency review to this case, it will still move forward in the lower court, and the United States government will be releasing some of the judgment, and we will see ultimately, what is the position that they take at the lower court level, and if this gets elevated once again to the 8th Circuit, what are they going to say, once this is fully implemented in some ways, and once this actually gets to get put in place, what does that look like, and what type of judgment will be issued by those courts. So unfortunately, the Supreme Court once again denied review and denied emergency review to this case and denied getting involved in this case at this time, but there is still hope and positive movement in favor of keeping Missouri SAPA law in place in some ways and seeing, how is this actually enforced, and maybe there doesn't need to be a total injunction on the entire SAPA law like the lower court granted to the Biden administration. The Trump administration is saying, okay, let's release some of that. Let's see maybe how this is implemented in some ways. What does this really look like? And then we'll go from there. So that appears to be what's now going to happen. We're going to see, does the United States government stay true to their promise once this gets back in the hands of the lower court? And that's going to be the big question. What happens now that the Supreme Court has denied this and it gets kicked back down to the district court? Will the Trump administration, will the U.S. government stay true to those promises? So as it develops more, as this unravels more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. Also, you can check out my website, armscholar.com. Over there, we have a lot for you guys. We have deals, coupons, and a lot of other things over there as well if you're interested. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.